So we are going to study emergency today. In this emergency chapter, we are required to study three kinds of emergency. One is national emergency, the second is president rule, and third one is financial emergency. Obviously, the name suggests national emergency will operate at uh, national level, that is for national issues, national concerns. President's rule is imposed in a state, so it is a state situation which is responsible for this. And third one is financial emergency, so that is on the ground of financial credibility or financial stability or disability or instability for that matter. So these are three kinds of emergency which is provided in part 18 of your constitution or our constitution. Now see, this emergency gives you enormous power to deal with emergent situation. Anybody will agree that there should be provision of emergency in any constitution because there can be emergency situation to deal with. And why do we need it? And especially in country like India, I tell you, a country which is federal country, there the power is divided between center and state. You also know this fact that in India, power is divided between center and state. Part 11 of constitution basically deals with legislative administrative relations where power is divided, read with schedule 7, 3 lists. And this scheme of distribution has been largely borrowed from Government of India Act 1935. So there is distribution of power between federal constituent, central government, state government. Whenever we see that there is any issue affecting the whole nation, the whole country, it is always in favor of federalism that center and state should work hand in hand. And that is why they have been given power also. Article 1 also says India, that is union of states. So it is union of states. So states have to play major role in the making of nation. So it's a federal country. And as in federal country, there is distribution of power. So obviously, the central government will be little bit weak in comparison to unitary government, where the power is united in one. So many scholars, Birch, there is a scholar Birch, Birch. Birch says that federal government is a weak government. And as it is weak government, so it is more required that it should have enormous power in the times of emergency to meet the exigencies of emergencies. In emergency situation, it should have enormous power to meet the exigencies of emergency. And this is what is reflected in part 18. E for emergency, E for 18. So there are exactly, this is exactly 18th chapter, 18th part rather, 18th part of constitution where emergency is provided, prescribed. All right. Now this emergency contemplates three kind of emergencies, as I have said, national emergency, state emergency, and financial emergency. Today we will be dealing with the first one, that is national emergency, Article 352. You see carefully Article 352, you will find This is part 18 of Constitution. 1 plus 8. It has exactly 9 clauses in 352. How many clauses? 9 clauses. But what you read today, 9 clauses of 352, is not original. It has also a history behind it. And that history is again very fascinating for understanding of Constitution. You know that in this country there has been era of parliament, then there has been era of executive, and then there has been era of judiciary. And it changes as per the time and as per the person. There was a time, the time of Indira Gandhi, which was known as era of executive, where Indira Gandhi, being the prime minister, she used to assert the power, and she used to take all calls. And she believed in herself, and she believed that she is the elected leader of the nation, and she has been voted by the people, democratically elected, powerful leader, the Iron Lady, and she has all the power to decide on behalf of the people of India, and correctly so. There is no doubt. If a prime minister is elected by popular voice, popular vote, it has the power. So that is what is to be understood in this particular journey of emergency. We'll talk about that. Let us begin with a reading of Article 352, and as and when required, we'll go in little bit history, we'll go in little bit future as well, and we'll see how this emergency provision has been effective. But for proper understanding, let me tell you there are certain questions which can be framed at the outset for proper understanding. You can frame your own questions, I can frame my own questions for proper understanding. When emergency can be imposed? When emergency can be imposed? You can write even short question, when. Who can impose emergency? Who can impose emergency? How decision of emergency will be taken? How decision of emergency will be taken? Does this need parliamentary approval? If yes, then within what time, by what majority? Within what time and by what majority? I repeat the questions. I said, when emergency? Who can impose emergency? How the decision of emergency can be taken, because it's a big decision which changes the character of entire constitution. So when emergency, who can impose emergency? How decision of emergency can be taken? Does it need approval of parliament? If yes, within what time and by what majority? By what majority? How it can be revoked? How it can be revoked? Is it required to be imposed in whole India or in any part of territory? Can it be imposed in whole India only, or can it be imposed in certain part of the territory of India as well? How it can be revoked? What is the process for revocation of this emergency? Many questions. Apart from that, there are other questions. What is the effect of this emergency? How does it affect Indian constitution? How does it affect federal fabric of constitution? How does it affect federal fabric of constitution? Does it affect fundamental rights as well? Does it affect fundamental rights as well? So, how it changes the relation between the government and the governed? Now, this emergency, which has been misused earlier, obviously Indira Gandhi is criticized for that. How to prevent the misuse of power? You can frame the questions in alternative. Emergency, which is enormous reservoir of power. There is need and necessity of necessary check on emergency provisions or on emergency powers. Do you agree, disagree? What are those provisions which put necessary limitation on power of emergency? So we can raise various questions like this. Let us address them one by one. How 44th Amendment, how 44th Amendment affected this emergency? 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 So there can be various kind of questions which can be raised. I hope you are clear about the question, because question clarity is must, and we'll try to find out the answer to these questions. Are you clear about these questions? You have to be careful, because if you understand the questions carefully in the proper backdrop, um, then understanding is in proper context. Let us address them one by one. So many questions, and there'll be questions in between also. Why we added armed rebellion? Why we deleted internal disturbance? Why we injected this, that the written decision of Union Cabinet is must? There are many questions within. Why in 356 and 360 approval time is 2 months? Why in 352 it is only 1 month? Why this change? Why approval in 356, 360 is by simple majority? Why in 352 it is different majority? Why? You can raise many questions. You can raise many questions. And it is not very difficult to answer all these questions, I must tell you. Why one emergency was in operation, which was imposed in 1971? And then why Indira Gandhi brought another emergency in 1975? What was the need? One emergency is already in operation, which was imposed in 1971 on the ground of Indo-Bangladesh war. It is in operation. Even then you imposed emergency in 1975. Why? So many questions are there. Variety of issues are there. Raising questions are very important. Henceforth, in all classes, and even earlier we have been doing this to a lot, we are concentrating more on questions, Because questions make things more interesting and absorbing. And I will request you also to read in the same fashion, because it will help you to understand, to memorize, to investigate, to absorb things better. So these are the questions. I hope you are clear about the question. So let us see the question and let us find the answer. Some of the answers will be very clear in Article 352 itself. You read Article 352, as I said, 1 plus 8 is 9. There are 9 clauses. And all clauses have some different idea. You pick the relevant idea, you remember even the clauses. Very simple. If you take up 352 clause 1, it talks of the ground. When emergency can be imposed, so it says emergency can see this is the question number 1 which I raised. When emergency can be imposed. So I already said 352 clause 1 answers. Emergency can be imposed when there is threat to security of India or any part of territory thereof. Any part of territory thereof. Can be imposed when there is threat to security of India or any part of the territory thereof. When there is threat to security of India or any part of the territory thereof. On the grounds of. On the grounds of war, external aggression or armed rebellion. War, external aggression or armed rebellion. So emergency can be imposed on these 3 grounds. Why? Because there is threat to the security of India. And tell me, when there is threat to the security of India or any part of the territory thereof, will you not take emergency action? The answer is yes. And how there can be a threat to the security of India? On the grounds of war, external aggression or armed rebellion. If there is war with other country, if there is external aggression like China and Pakistan, other countries now have transgression in Indian territory, or they have shown their aggressive attitude and approach towards your boundary and towards your people. So now external aggression, this is how your security is threatened. War is a little formal affair where 2 sides must be engaged, whereas external aggression can be unilateral, where one country attacks the another, and then there can be a development of formal war or armed rebellion. Earlier it was internal disturbance, now it is armed rebellion after 44th Amendment. Armed rebellion when people have reason with the arm and there is a rebellion, there may be. Many countries face this kind of situation, IS and something like that. Armed rebellion, not rebellion, armed rebellion. So that is also security threat, internal security threat. So that can be a ground for emergency. Who can impose the second question? You have taken the question and now you take the answer one by one. Who can impose emergency? So obviously, when president is satisfied, that there is threat to security. And on that ground, the grounds you have mentioned, threat to security. President is satisfied. Now this satisfaction is satisfaction in constitutional sense. This is satisfaction in constitutional sense. This is satisfaction in constitutional sense. This is satisfaction in constitutional sense. And what is satisfaction in constitutional sense? Satisfaction in constitutional sense means satisfaction in constitutional sense means satisfaction as per the constitution. And what is satisfaction as per the constitution? I must tell you, it is satisfaction on the advice, aid and advice of Council of Ministers headed by Prime Minister. So it is not president's satisfaction. Satisfaction in constitutional sense means satisfaction of wherever it is written. Whether now many people will argue wrongly wherever it is written. It is not president's personal satisfaction. It is president's constitutional satisfaction. And president's constitutional satisfaction is satisfaction of Council of Ministers headed by Prime Minister. So it is not president who will take the call, it is Council of Ministers headed by Prime Minister which will take the call. Be careful. So when the Council of Ministers headed by Prime Minister come to the conclusion that there is threat to the security of India due to war, external aggression or armed rebellion, then President is constitutionally satisfied that there is threat to the security of India, and then he can impose national emergency in India. So first two questions are answered. Now then you raise the question, how this decision will be taken. Let me tell you on this point. Third question. How this decision, so it says written advice of Union Cabinet. President will impose written advice of Union Cabinet. So it is not basically Council of Ministers now, it is Union Cabinet, and the word cabinet has been used in Article 352. It is nowhere used. It is in Article 352 Clause 3 which we are using here, Union Cabinet. So it is not advice of COM, this is advice of COM is general, major and procedure. Here it is advice of Council of Ministers, not Council of Ministers, rather it is advice of Union Cabinet. And Union Cabinet will include Prime Minister and Ministers of Cabinet rank. Cabinet rank ministers are ministers of higher rank. Now you might be knowing Home Minister and Finance Minister and Foreign Minister. Now all these Defense Minister, they are minister of Cabinet rank. The most senior ministers of the government is Cabinet Minister. They sit in Cabinet meeting. You must have heard Cabinet Committee on Security Affairs. So this is cabinet which takes the call. In many cases, it is cabinet. Not all ministers. Now, Council of Ministers is all minister. Cabinet minister, state minister. There is finance minister Nirmala Sitharamanji, and then there is a young man who is also state minister of finance. So that young man is not cabinet minister. He is not cabinet minister. He is a state minister. So he is deputy in that sense. In many ministries, in big ministries especially, we do it. So you must understand that Union Cabinet is subset of Council of Ministers. It is a smaller coterie of ministers of higher rank which enjoys the status of cabinet minister. Is this clear? And they will take the call. Now you read clause by clause this Article 352 and you see carefully that what are the other. I raised further question. When it will be imposed, so I said three grounds. Who will impose? President. President should be constitutionally satisfied. Constitutional satisfaction means generally satisfaction of council of minister, but here it is modified. It is written advice. So whenever he wants to impose emergency, it has to be written advice. Not even oral advice, it is written advice. Now, you may ask a question why it is written categorically here, though it is nowhere written. Because what happened in 1975, I tell you, Indira Gandhi ji imposed national emergency. And she did not consult ministers. So now the question was raised. No formal procedure was followed. The question has been raised that why and how an individual can take a call. It should have been a collective will, collective wisdom, collective decision. And that is why when this Janta government came into power, they enacted this, they provided this by 44th Amendment. So all the misuses which have been done earlier has been curbed by 44th Amendment of Constitution in 1978 during Janta Party regime. Is this clear? So, written advice. It should not be oral advice. Now, what Indira Gandhi did in 1975, she gave oral advice to the president, and later on she might have given written advice and written everything, because formality has to be complied with. But it was written, it was unwritten. Fakhruddin Ali Ahmed Sahab was the president and Indira Gandhi was the honorable prime minister. So Indira Gandhi ji advised Fakhruddin Ali Ahmed Sahab, and Fakhruddin Ali Ahmed Sahab imposed emergency in the night of 25th June 1975, and that too on the ground of internal disturbance. When a question was asked, what is internal disturbance? So Indira Gandhi answered in parliament, two kind of questions were raised. That did you consult your council of minister? Then the prime minister answered that there is a rule of business in parliament, and this rule of business allows president or rather prime minister to take decision on behalf of council of minister. President is not, or rather prime minister is not duty bound to take advice of all council of minister all the time. It is not required. She can or he can take a decision on behalf of entire council of minister, and this is provided in rule of business 28 clause B in parliamentary rule of business. So she justified her stand. Now then, when she was asked the question, that how did you reach that there is internal disturbance? We can't see internal disturbance in India. India is all right. India is peaceful. India is quiet. India is exactly at the same position. Where is internal disturbance? She said certain people are trying to incite our military forces and police forces not to obey the government, and this is what is causing internal disturbance. Where is the proof? How did you reach to this conclusion? Nobody knows. So, in reality, this was not internal disturbance, I must tell you. The ground was something different. Indira Gandhi was defeated in election and she was afraid of losing the power, the seat. And her zeal to work for the country and her zeal to serve the nation in the capacity of prime minister compelled her to take this kind of decision, which proved fatal for her political career. So Indira Gandhi imposed emergency in the night of 25th June 1975, quoting the ground of internal disturbance, which was really a vague ground. How can you define what is internal disturbance? Anything can be internal disturbance going by Indira Gandhi's opinion. So that is why Janta government, when it came by 44th Amendment, it amended constitution, it altered constitution, it provided these two-way procedures, the two-way safeguards in the constitution. On one hand, she wrote written advice of Union Cabinet, not of all. And the second, the government, Janta government provided that this should be only on the ground of armed rebellion, not internal disturbance. So internal disturbance was deleted, armed rebellion was added. So there has been substitution of armed rebellion instead of internal disturbance. So now the three grounds which stands: war, external aggression, and armed rebellion. Is this clear? So now you can impose national emergency on the ground of armed rebellion, not on the ground of internal disturbance, and this can be done only on the written advice of Union Cabinet, not otherwise. So Prime Minister cannot take decision individually and alone. It is a constitutional command and it has to be obeyed by the all succeeding Prime Ministers. Is this clear? Is this clear? Now you read this clause 4 and you see what is there in the clause 4 of your Bear Act. What it says, if you see, now you must understand, see, behind every provision we have some logic, we have some ground. Now, what is the form of government which we have adopted? This federal country, all right. But what is the form of government? Is it presidential system or it is parliamentary form of government? So obviously you will say it's parliamentary form of government. When it is parliamentary form of government, tell me, who will take all the decisions finally? Is it parliament or is it president? अंतिम निर्णय किसका होगा, संसद का या राष्ट्रपति का? If you come to the position or take the position, ये राष्ट्रपति का होगा, तो this is presidential system. If you come to the conclusion that it has to be of parliament, then it is parliamentary form of government. And as far as you know, I know that India is committed to parliamentary form of government, and it says that Council of Ministers shall be collectively responsible to the House of People. Article 75 is there, which clearly says that Council of Ministers shall be collectively responsible to the House of People. Council of Minister. Council of Minister. Just try to understand the point. Council of Ministers shall be collectively responsible to the House of People. Council of Ministers. So, who has the upper hand? Now, House of People is the final authority to scrutinize your all decisions. If you have majority in House of People, you can rule, you can command, you can control the country. If you do not have majority in Lok Sabha, you cannot do it. So obviously, Constitution has taken the similar course. And it says that this decision of Union Cabinet has to be brought, has to be led before Parliament. Clause 4. And Parliament has to approve it within limited time. So read clause 4 carefully. It says, every proclamation issued under the shall be laid before each house and shall accept where it is proclamation provoking a proclamation. What it says, the president shall cease to operate at the expiration of 1 month. So, sorry, you have been given time of 1 month to approve this. 1 month time. Now, you may raise a question. If you compare and contrast Article 352 with 356 and 360, you find that in 356 and 360, it is provided that the time of approval is 2 months. Why in 352 it is 1 month? The reason is but obvious. That, see, this is emergency. And emergency has a far-reaching consequence in the country. It changes the federal constitution into unitary one. It changes the federal constitution into unitary one. So this decision, which has been made by Union Cabinet and which has been in operation for few days, it must be approved by Parliament within 1 month. So We have given you limited time. Earlier this was 2 months. By 44th Amendment, again the time period was election. So see how the enormity of the power which could have been misused by any succeeding government after Indira Gandhi has been minimized. Earlier it was 2 months. So earlier, if a mischievous prime minister is there, he can keep it in operation for 2 months without approval of parliament. He may not have a majority in parliament. He may not have majority in Lok Sabha for the timing. It may happen. Or many of his friends may not be supporting his decision. Even then, he can keep it in operation for 2 months. So that situation should not occur. It should be in operation for minimum time before parliamentary approval, because parliament is reflective of the will of people. So let parliament take a call, and that too within limited time of 1 month. So we have reduced the time period of approval from 2 months to 1 month. So unless and until it is approved within 1 month by both the houses of parliament, it cannot remain in operation beyond 1 month. So within 1 month it has to be approved. Time period has been lessened. Earlier it was 2 months, I said. Now it is 1 month. Now it says further provided. Now when this proclamation is issued, when House of People is not in session. Now this is interesting. House of People is not in session, and Rajya Sabha approves it within 1 month. Time for approval for both houses is 1 month. Time one month by both. Now within this 1 month, what happens? Lok Sabha is dissolved or was dissolved earlier, and Rajya Sabha approves the emergency. Then what will happen? And now condition was it has to be approved by both houses. Rajya Sabha approves it within 1 month. But within 1 month, Lok Sabha is dissolved. It is no more there. Or was dissolved. It was dissolved beforehand. It was dissolved even before emergency was up. So what will you do? So it says in this case, see, Lok Sabha is the real house. It has to get the approval of Lok Sabha. So Lok Sabha is the real house. You have to get approval of Lok Sabha. So it says simply wait till election of Lok Sabha, and when Lok Sabha comes into then give it time of 30 days for approval of for approval of for approval of emergency. Now, once it is approved in the first way or here after 30 days, within 30 days of Lok Sabha election, then this emergency will remain in operation for 6 months from the date of passing of second resolution. Here it is second resolution, Lok Sabha's resolution. Lok Sabha will approve it later on. Rajya Sabha has already approved it. So it will remain in operation from the date of passing of resolution by Lok Sabha, approval by Lok Sabha. Then it will continue for 6 months in one go. If you want to continue it further, then again you can approve it within those 6 months. Both houses can approve within 6 months, and then just after 6 months, the fresh period of 6 months will begin. So just try to understand the point. There may be a preliminary question that, see, in first case when 6 months will begin to run, it is from the passing of second resolution. Either it is Rajya Sabha resolution or Lok Sabha. Second, first house has approved, then second house approves. It can be Rajya Sabha first, it can be Lok Sabha first. So which house approved letter, from there will count 6 months in first go. 6 महीने की काउंटिंग कहां से होगी? तो उस तारीख से होगी जिस तारीख को सेकंड रेजोल्यूशन पास हुआ. इज दिस क्लियर? जिस तारीख को सेकंड रेजोल्यूशन पास हुआ उस तारीख से 6 महीने का समय. दिस वाज इन फर्स्ट सिचुएशन. इन सेकंड सिचुएशन अब 6 महीने जब खत्म होता तो वहां से 6 मंथ्स रन करना शुरू हो जाएगा. And before that expiry of 6 months, you have to get approval of both houses. Is this clear to all? पहला अप्रूवल पहले राज्यसभा ने कर दिया 1 जनवरी 2020 को. सेकेंड, इट वॉज अप्रूव्ड ऑन 1 February 2020 बाई लोकसभा और 30th January 2020 बाई लोकसभा. सो 30th January से 6 महीने काउंट करेंगे हम. तो 30th January से करेंगे तो फरवरी, मार्च, अप्रैल, मई, जून, जुलाई. तो ये 30th जुलाई तक आपको समय है. 29 जुलाई तक समय है आपको. तो आप क्या करेंगे, अब 30th जुलाई से फिर 6 मंथ शुरू हो जाएगा. बट बिफोर 30th जुलाई you have to get approval of both houses. Remember this. Is this clear? Always it is approval by both houses. Why we are talking of approval of both houses, you must understand, because it affects federalism. So approval of Rajya Sabha is also must. It cannot be only approval of Lok Sabha. ये each house से approval होना है. It has to be approved by both houses of parliament. It has to be approved by Lok Sabha, it has to be approved by Rajya Sabha. Is this clear? Now, clause 5 says, proclamation so approved shall unless revoked cease to operate on the expiration of period of 6 months from the date of passing of the second resolution, provided that if and when so a resolution approving the continuance in force of such program is passed by both houses, the proclamation shall unless revoked continue in force for a further period of 6 months from the date on which it would have otherwise ceased to operate. तो दूसरा 6 महीना तो 6 महीने खत्म होने से शुरू होगा. Is this clear to all? And suppose suppose कि अब आपने एक बार अप्रूवल कर दिया, दोनों हाउसेस का अप्रूवल एक बार हो गया, सेकेंड रिजोल्यूशन से 6 महीने चलेगा. ये तो क्लियर है आपको. एक हाउस ने 1 तारीख को किया, 1 जनवरी को किया, दूसरे ने 30 जनवरी को किया. तो अब 30 जनवरी से 6 महीना आप काउंटिंग कर लेंगे पहले बार में. ये तो कोई दिक्कत नहीं है, तो बहुत सरल है. तो फरवरी का महीना गया, मार्च गया, अप्रैल गया, मई गया, जून गया, जुलाई तक चलेगा ये, ठीक है। अब आप जुलाई के पहले दोनों हाउस से अप्रूवल करा दो, तो फिर जुलाई से 6 महीने चलेगा ये। अगस्त, सितंबर, अक्टूबर, नवंबर, दिसंबर, जनवरी तक चलेगा अब ये। सपोज करो कि इस अगस्त से जनवरी जो नेक्स्ट 6 मंथ्स था, उसमें फिर से लोकसभा डिसॉल्व हो गई और लोकसभा अप्रूव नहीं कर पाया। Is this clear? Only Lok Sabha can be dissolved, Rajya Sabha cannot be dissolved. Rajya Sabha is a permanent house. So Rajya Sabha will remain in operation always. Will remain in existence. It will remain in existence always. Lok Sabha is dissolved. So suppose Lok Sabha is dissolved in next 6 months. So you cannot get approval of Lok Sabha now. So what will you do? Again, sir, you will have to wait till election takes place and Lok Sabha is given 30 days time. Lok Sabha is given 30 days time. Here it is 30 days, mind you. आपको सिर्फ मेरी बात ध्यान से सुननी और कुछ नहीं करना है, सारे क्वेश्चन का आंसर आ जाएगा जो आप पूछ रहे हो। 30 days. From the date of its first sitting. जिस दिन पहली बार लोकसभा बैठेगा उस दिन से 30 दिन को आप काउंट करोगे। यू विल काउंट 30 days फ्रॉम द डेट ऑफ इट्स फर्स्ट सिटिंग। इज दिस क्लियर? You will count 30 days from the date of its first sitting. You will not count now 30 days from the day of election or something like that. No, it has to be this way. Is this clear? 30 days. Now, this way 6 months, 6 months, 6 months you can go indefinite. But you will have to approve it for 6 months only. One time approval is for 6 months only. It cannot be beyond that. Now, for how many months emergency will remain in operation, that is, and how many years, there is no upper limit. Now see, once emergency was imposed, I tell you, in 1971, after this Indo-Bangladesh war, I have written in your material also. If you can see your material, page 342, 3rd December 1971. And it remained in operation till 20th March 1977. अब देखिए आप 3 दिसंबर 1971 को इमरजेंसी लगी और ये इमरजेंसी 20 मार्च 1977 तक ऑपरेशन में रहा। तो होल 72, 73, 74, 75, 76 होल 5 साल एंड 77 में भी तकरीबन 3 महीने एंड 71 में भी 1 महीने। तो 5 years 4 months इमरजेंसी वॉज इन ऑपरेशन। सो देयर इज नो अपर लिमिट ऑफ नेशनल इमरजेंसी। नेशनल इमरजेंसी का कोई अपर लिमिट नहीं होता है। 6 months, 6 months, 6 months आप कंटिन्यू कर सकते, बट one time it can be 6 months only. Is this clear? And then you can extend the duration of Lok Sabha and Vidhan Sabha also. There is provision in Article 83 of Constitution and Article 72 of Constitution whereby you can do it. Article 83 and 172. In both cases, Parliament can extend the duration of Lok Sabha and Vidhan Sabha. That is Parliament's prerogative, it can do. 5 महीने की जगह हर बार 1 साल के लिए आप बढ़ा सकते हो। यू कैन एक्सटेंड ड्यूरेशन ऑफ लोकसभा बाय 1 year एट ए टाइम बाय मेकिंग ए लॉ। This is also an example of constitutional amendment by simple law-making process. There can be many amendment in this constitution by simple law-making methods. Now, in 83, there is duration of parliament, duration of Lok Sabha, and it is for 5 years, and you can extend it by 1 year. Is this clear? And you can make it 6 years. 1 year at a time. Again, it is not permissible that you extend the time for many years. No, no, no. It is not possible. 1 year at a time. Is this clear? 1 year at a time. तो ध्यान यही रखना है कि पहली वाली जो इमरजेंसी का समय है 6 months, वो सेकंड रेजोल्यूशन है. दूसरा जो 6 महीना शुरू होगा वो पहले 6 महीने समाप्त होने से शुरू हो जाएगा. उसमें कोई सेकंड रेजोल्यूशन का चक्कर नहीं है. देयर इज नो क्वेश्चन ऑफ सेकंड रेजोल्यूशन, बिकॉज सेकंड रेजोल्यूशन विल ऑलवेज बी पास्ड before cessation of this first resolution, or rather the first approval of emergency, that is duration of 6 months. तो 6 months जब खत्म हो रहा है वहां से अगला 6 महीने शुरू हो जाएगा. सेकंड रेजोल्यूशन तो पहले ही पास हो जाएगा 6 महीने के अंदर ही. तो बस इतना ही ध्यान रखना है. और जो 30 डेज का टाइम है, ये 30 डेज टाइम फॉर लोकसभा इज फ्रॉम द डेट ऑफ इट्स फर्स्ट सिटिंग. ध्यान रखना, फर्स्ट सिटिंग. ऐसे क्वेश्चंस आपको प्रिलिमिनरी में आएंगे. बेयर एक्ट को ध्यान से पढ़ना होगा आपको. अब अगला सवाल आपके सामने है. नाउ देयर इज नेक्स्ट क्वेश्चन बिफोर यू. व्हाट इज द मेथड ऑफ अप्रूवल ऑफ दिस proclamation of emergency? Whenever I use the word proclamation of emergency, it means emergency under Article 352. आप ध्यान से जब पढ़ोगे डेफिनेशनल क्लॉज को 366 को, तो उसमें आपको ये बातें मिलेंगी. पढ़ा है कभी आर्टिकल 366? पढ़ते यू मस्ट रीड एटलीस्ट वंस 366. यू मस्ट डेवलप दिस हैबिट कि डेफिनेशन को हम पढ़ें. देखो क्लॉज 18 में बड़ा आसान है. इमरजेंसी 18, यहां भी 18 है. तो प्रोक्लेमेशन ऑफ इमरजेंसी मीन्स ए प्रोक्लेमेशन इशूड अंडर क्लॉज 1 ऑफ आर्टिकल 352. प्रोक्लेमेशन ऑफ इमरजेंसी मीन्स इमरजेंसी इन 352. इज दिस क्लियर? अब देखिए आगे चलते हैं. ये ड्यूरेशन क्या होगा? आपने पूछा ये अप्रूवल का मेथड क्या होगा जी, कैसे अप्रूवल करोगे? तो प्रोसीजर फॉर अप्रूवल, dual majority. I hope Nilima Tiwari and Bairwa, this is clear to you. इसमें अननोन भी है, अननोन नहीं होना चाहिए. Nilima Tiwari, is this clear to you? And Bairwa also, is this clear to you? Whatever you asked, just reply. So how emergency will be approved by Parliament? So it will be approved. बहुत सिंपल है. डुअल मेजॉरिटी. डुअल मेजॉरिटी मैंने कई बार यूज कर दिया. यू अंडरस्टैंड डुअल मेजॉरिटी? आई सेड, चूंकि ये मेजॉरिटी दो है, मेजॉरिटी ऑफ टोटल एंड मेजॉरिटी ऑफ 2/3 present and voting. Majority of 2/3 present and voting. ये अमेंडमेंट में भी यही पढ़ा था, डुअल मेजॉरिटी. इज दिस सो और नॉट? लेट मी चेक इट ऑल्सो. Total membership, clause 6 says in majority of not less than 2 that are present and voting. Yes, clear. Dual majority. Is this clear? So clause 6 is clear that way. Now let us come to another clause. So, what is the next one? The president shall revoke a proclamation on proclamation if the House of People. Now, see, I raised a simple question and I say it's a parliamentary form of government, so parliament must take all final decisions. ये संसद को सर्वोच्च अधिकार है कि वो हमारे संविधान में ऐसे मूलभूत निर्णय अंतिम रूप से लेगा. This is prerogative of parliament to take all final call about constitution, especially in these matters, emergency, etc. So it has to be approved by parliament. So now suppose if parliament says it should not remain in operation, I tell you, before 1978, before 44th Amendment, there was no such provision. Once parliament takes or approves it, then it goes in the domain of executive. Now executive will revoke or will not revoke, that is their domain, that is their discretion. But after 44th Amendment, this provision has been done away with. इस चीज को हमने समाप्त कर दिया. Now it is not within the prerogative of executive. If Lok Sabha says it has to be disapproved, it has to be revoked, it has to be revoked. ये लोक सभा का प्रेरोगेटिव होगा. लोक सभा कहेगी कि इसको खत्म करना है तो ये खत्म होगा. ये प्रेसिडेंट के ऊपर और प्राइम मिनिस्टर के ऊपर, काउंसिल ऑफ मिनिस्टर के ऊपर और एग्जीक्यूटिव के ऊपर नहीं है. ये किसके ऊपर है? ये लोकसभा के ऊपर है. तो क्लॉज 7 वही कहता है कि इफ लोकसभा says that it has to be disapproved, it has to be revoked, now it has to be revoked. There is no executive's prerogative. Executive can't deny it. Executive has to obey the call of Lok Sabha. I think the language of constitution is categorical and clear. Now let us read the constitution itself. It says, notwithstanding anything. Now see the language contained in the foregoing clauses. भूल जाओ सारी बात. The president shall revoke a proclamation issued under clause 1 or a proclamation bearing such proclamation if the House of People passes a resolution disapproving, or as the case may be, disapproving the continuance in force of such proclamation. So it is prerogative of president. No. It is prerogative of Lok Sabha. Earlier it was prerogative of president before 44th Amendment. पहले ये व्यवस्था थी, पहले ये व्यवस्था नहीं थी, clause 7 नहीं था. There was no clause 7 beforehand, before 44th Amendment of Constitution. So before 44th Amendment of Constitution it was possible, but now it is no more possible. आपको कह दिया लोकसभा ने इसको रिवोक करो तो आपको रिवोक करना होगा. अच्छा, रिवोकेशन का क्या मेथड और भी हो सकता है? तो कह रहा है वेयर ए नोटिस इन राइटिंग साइंड बाय नॉट लेस देन 1/10 ऑफ टोटल नंबर ऑफ द मेंबर्स ऑफ द हाउस ऑफ पीपल हैव बीन गिवन ऑफ देयर इंटेंशन टू मूव ए रेजोल्यूशन फॉर डिसअप्रूवल एज द केस मे बी. अब लोकसभा को कराना है डिसअप्रूवल, तो कौन देगा ये नोटिस इन राइटिंग? तो वही लिख रहा है हाउस ऑफ पीपल के मेंबर्स देंगे. For disapproving the continuance in force of a proclamation issued under clause 1 or a proclamation bearing such proclamation. अब देखो लोकसभा if it is in session, so हाउस ऑफ पीपल को करना है. हाउस ऑफ पीपल को करना है ये. इज दिस क्लियर? तो कैसे करेगा? तो 1/10 मेंबर. Intention for disapproval in writing signed can give A resolution for disapproval. To Speaker if House in session. To President if House not in session. जरा ध्यान से देखिए कितना बारीक सी बात है. It is very simple thing, by the way. तो यदि हाउस सेशन में नहीं है, then you give to president. If house in session, then give to speaker. Because who will call the house in session? President. If it is not in session, we cannot discuss this. President will call it in session. President इसको सेशन में बुलाएगा हाउस को. तो प्रेसिडेंट को ये दो जानकारी. If we want to get this disapproved. This is logical. People say that we are required to remember. I say that you are required to understand. And this is the irony, that we do not understand that there is need of understanding. If house is in session, discussion can be initiated by speaker. If house is not in session, discussion has to be, or rather, house has to be called in session by the president only. This is quite clear, I hope. क्यों हमने एक जगह स्पीकर लिखा, क्यों दूसरी जगह प्रेसिडेंट लिखा? And this can be a good question. A special sitting of house shall be held within 14 days. कितने दिन के अंदर बुलाओगे? तो स्पेशल सेशन, अब देखो ये सब आपको ध्यान रखना है. Within 14 days from the date on which notice was received. Now, clause 9 clarifies that power conferred on president by this article shall include the power to issue different proclamation on different grounds. And this has been done. इंदिरा गांधी ने किया था. ये तो पहले से भी था. ये क्लॉज पहले से भी था. इंदिरा गांधी had already emergency in operation which was imposed in 1971, 3rd December 1971, which was revoked on 20th March 1977. Then even on 25th June 1975, she imposed another emergency on the ground of internal disturbance. See, because you cannot justify all your actions within India which is on the ground of external aggression. So, if there is external aggression, you cannot justify a decision on the ground of external aggression against your own people. Many things. That may be, external aggression may require certain things. You may be required to send your resources there. You may be required to do foreign diplomacy. You may be required to send your army. You may be required to divert your resources. That is justified. But how can you curb the democratic rights of people on the ground of external aggression? This is very difficult. Indira Gandhi wanted to curb the democratic rights. She wanted to impose embargo on the liberty of the people. So could she have justified that on the ground of emergency, imposed on the ground of external aggression? The answer is no. And that is why she was required to impose emergency on the ground of internal disturbance, because her ground was that certain people are instigating my armed forces and police forces not to obey the government, and this will create anarchy in the country, and that is why I am imposing emergency, and I am basically arresting and putting all these people behind bars, those who are inciting, instigating, supporting, activating, sympathizing with those people who are against government. And that is the story of 1975. Is this clear? So there can be different proclamation on different grounds which can be imposed in nation wide Article 352 by the President. I hope you understand the basic clause and you have got the answer to the maximum question. But now let us move further. And let us see that what kind of changes have been brought by 44th Amendment and what is the consequence. These are two major questions. Safeguard. I have written in your material also safeguard by 44th Amendment and this uh, consequences of proclamation of emergency. Consequences of proclamation of emergency. So first you discuss consequences, then now if you ask me this question in one word, I can tell you that the consequence of emergency is that it changes federal constitution into unitary constitution. So simple. Because all the powers of state is also exercised by center at that time. Center can rather let me be very particular. I made a bold statement, very wide statement. So let me tell you what happens. That center gets enormous power. It gets overriding power. Basically, state subjects become concurrent subjects in that sense. And center can make law in state subjects also. So that is how it becomes unitary in that sense. Now there is no much the state can do against the wish and will of center, and this is necessary because if we fight war, if we fight against some enemy, we need united concerted action from us, and this united concerted action will be possible if I am in control and command of the situation. If one person and one government does not take a call and everybody starts taking decision, can it happen? The answer is no. Everybody has his or her own concern. They have their own interest. So no decision will be possible. So you will have to give clear command to one controlling authority. And here that authority is center only. So this is what I said. It makes federal government a unitary government. Now you can see this and then you can understand this beautifully. Now the moment I said federal unitary, you understand where is the distribution of power. Now you know that there is distribution of power in case of legislature, there is distribution of power in executive, there is distribution of power in revenue in a sense. Revenue distribution is also there. That is what is the same. So between center and state, see how we can remember legislature related. So effect on legislature, executive related, finance related, and fundamental right related. This is not between center and state. This is not between center and state, but fundamental right related. So these are four major points under which you can remember the consequences. This is how you can memorize things better. You can create your own synopsis. You can make your own powerful and PowerPoint presentation. So as far as legislative is concerned, you see there is provision. मैंने एक बनाया भी है इसका चित्र. आर्टिकल वाइज आप भी बना सकते हो, कुछ है नहीं, बहुत सिंपल है. कौन कौन से आर्टिकल किस में आते हैं यही लिखा है हमने. तो देखो 353 में 353A 353B देखा होगा. लेजिस्लेटिव रिलेशन 350B है. आर्टिकल 353B और एग्जीक्यूटिव रिलेशन आर्टिकल 353A. फाइनेंस वाला 354. Fundamental right, Article 358, Article 359. Is this clear? अब 353B ने क्या कहा, आप उसको पहले देखो। 353B में क्या लिखा है, जस्ट समझ के लिए बता रहे। द पावर ऑफ पार्लियामेंट टू मेक लॉ विद रिस्पेक्ट टू एनी मैटर शैल इंक्लूड द पावर टू मेक लॉज कन्फरिंग पावर एंड इम्पोजिंग ड्यूटीज। सो पार्लियामेंट कैन हैव पावर टू मेक लॉ विद रिस्पेक्ट टू एनी मैटर, notwithstanding that it is one which is not enumerated in union list. So what happens by virtue of 353B, that parliament gets power, parliament can make law on all list. तो ये यूनिटरी हो गया कि नहीं बताओ, दिस इज व्हाट आई वांटेड टू से। ऑल लिस्ट, स्टेट लिस्ट भी आ गया। पार्लियामेंट कैन मेक लॉ ऑन ऑल लिस्ट, दिख रहा है आपको, कैन यू सी दिस, पार्लियामेंट कैन मेक लॉ ऑन ऑल लिस्ट। मैं फिर से लिख देता हूं, Parliament can make law in all lists. That is list 1, list 2, list 3. So this is how it can become unitary. This is what is 353B. Is this clear? भाई मेरी बात आप समझ पा रहे हो कि नहीं? 353 भी देख लिया आपने, पार्लियामेंट कैन मेक लॉ इन ऑल लिस्ट, क्लियर है? लेजिस्लेटिव पावर। दूसरा आर्टिकल 250 में भी लिखा, ड्यूरिंग इमरजेंसी पार्लियामेंट बिकम्स empowered to make law with respect to any matter enumerated in a state list. So peacetime distribution of legislative power between center and state is basically rearranged, realtered. So Article 245. Parliament can make law in a state list during emergency. मेंस में भी आपको ऐसे ही लिखना है, वो 1 point each. आप बहुत ज्यादा लिख नहीं पाएंगे। Many people have some kind of confusion. मेंस में क्या लिखूं? मेंस में भी यही लिखोगे, एक एक लाइन में लिखो। देखो कितना पावरफुल लाइन है। 353 से 353B से पार्लियामेंट कैन मेक लॉ इन ऑल लिस्ट, पार्लियामेंट कैन मेक लॉ इन स्टेट लिस्ट ड्यूरिंग इमरजेंसी। देखो मैंने बहुत ब्रीफली लिख दिया ये। इज दिस क्लियर? अब लेजिस्लेचर में और व्हाट इज देयर मोर, आई टेल यू मोर, आई टेल यू मोर। You can extend the duration, extension of duration of Lok Sabha, Article 83, and Vidhan Sabha, Article 172. And you are not required to remember anything. Just say 83, I said 83, so you know 172. How? You add 89. I've told you formula of 89. नहीं बताया जान लो आज। So if you remember one or you remember another, generally it will work. You add 89 in union article, you get state articles. Extent of executive power of union, extent of executive power of union 73. You add 89, 162. देखो यही है. This is there. It's magic. So, furthermore, uh, is this clear? Extension in duration of house 83 and 172. ध्यान रहेगा. In both cases, I told you there can be extension of 1 year, and in no case it can extend beyond 6 months after emergency has ceased to operate. Now, just make this clear in your mind. The extension of duration of Lok Sabha or Vidhan Sabha can be by 1 year by law. 1 year by law. 1 साल बढ़ा सकते हो. And in no case it will operate beyond 6 months after cessation of emergency. In no case it will operate beyond 6 months after cessation of emergency. इमरजेंसी के बाद 6 महीने से ज्यादा ये लागू नहीं रहेगा. Is this clear? So emergency खत्म होने के बाद 6 months. Before that, it can extend 1 year. So 1 year is the maximum time you can extend, and in no case, suppose करो emergency पहले ही खत्म हो गई. You extended the time period, now suppose in January by 1 year, January 2020 by 1 year, and emergency ceased to operate in March 2020. So in no case beyond 6 months. So March 2020 it ceased to operate emergency, so it cannot continue beyond April, May, June, July, August, September. So it cannot continue beyond September. So emergency समाप्त होने पे maximum 6 महीने, but maximum limit है 1 year. अब जैसे इमरजेंसी समाप्त हुई जाकर के सितंबर में, so can it continue till October, November, December, January, February, March? No, क्योंकि 1 साल के लिए आपने बढ़ाया था तो ये दिसंबर में ही खत्म हो जाएगा. 6 महीने 1 साल दिसंबर में ही खत्म हो जाएगा. यानी जनवरी में यू नीड ए न्यू लोकसभा. जनवरी यू नीड न्यू लोकसभा. अब एग्जीक्यूटिव पे आते हो तो एग्जीक्यूटिव में देयर इज सिमिलर प्रोविजन 353A. During emergency, the executive power of union extends to giving direction to any state as to the manner of. So, इसमें लिखोगे आप one line, center can state, center can direct state. About exercise of executive power. Executive power. Executive power. Center can direct a state to exercise finance. भाई सब कुछ बदल गया, फिनांस तो बड़ा इंपॉर्टेंट है. तो 354 में लिखा है, पढ़ लो 354. जस्ट क्लास के बाद यू मस्ट हैव ए ग्लांस ऑन बेयर एक्ट. The President may, while a proclamation of emergency in operation by order, direct that all or any of the provision of 268 to 279 shall for such period not extending in any case beyond the expiration of the financial year in which such proclamation ceases to operate as may be specified in the order, have effect subject to such exception or modification as it thinks fit. So, direct all or any of the provision of have effect subject to such every order made under shall as soon as may be after it is made be laid before each house of parliament. तो आप उसको, so there is alteration of arrangement, arrangement in article 268 to 279. 268 to 279. 12 articles. 12 articles. Have subject to such exception and modifications. So exceptions, modifications का मतलब ही हो गया कि 268, 279, 268 to 270, whatever is the arrangement that can be modified, that can be changed, that can be altered according to the situation. उसको हम फेर बदल कर सकते हैं. उस finance में हम फेर बदल कर सकते हैं. This is what is written. Now, as far as effect on fundamental right is concerned, as far as effect on fundamental right is concerned, it is very simple. 358 and 359. Now 358 says that there will be automatic suspension of Article 19 when emergency is imposed on the ground of war or external aggression, not in case of armed rebellion, mind you. Not in case of armed rebellion. There is no automatic suspension of fundamental right in other cases. It is only in case of war and external aggression. It is only in case of war and external aggression. So on that point you can write very carefully. Article 358, Article 359. I have written in your material also. So in 358, automatic suspension. Of Article 19. No automatic suspension. Need of President's order. जब भी एग्जाम में लिखें तो कंप्लीट सेंटेंस लिखें. On the ground of war or external aggression. Here President by order can suspend all FR except Article 20 and 21, all fundamental right except Article 20 and 21, so Article 20 and 21 cannot be suspended. Can suspend all fundamental right. In any case, in all situation of war, external aggression, or armed rebellion. In all cases. In all cases. There is no automatic suspension in 359. This is the major point of distinction. There are other points written in the material, just see it. It says 359 operates only in case of external emergency. That is what I have told you, automatically suspends. It relates to Article 19 only, that is already I have said. Now let me tell you one more point which is very pertinent and which you must know. And I will advise you to read on that as well. And that is very simple. So, Article 358 suspends Article 19. And if you read Article 359, it says it suspends enforcement. No? If you see the point number 2 in your material, page 344 also, it said it only empowers the president to suspend enforcement. So, what is the meaning that you cannot go to court for enforcement of fundamental right during emergency? This is what is the meaning. जैसे मान लीजिए अभी इमरजेंसी लग जाए, भारत चाइना के बीच में चल रहा है प्रॉब्लम, और राष्ट्रपति कहें प्रेसिडेंट सस्पेंड्स आवर fundamental right, some of fundamental right except 20 and 20. Can we go to court for enforcing our fundamental right? The answer is no, you can't go. अभी नहीं जा सकते. But later on, after emergency, one can go to court. But here it suspends Article 19 all itself. Article ही समाप्त हो गया आपके लिए during emergency. So, if I ask you a question that if Article 19 was not there with you during emergency, can you go to court after emergency complaining violation of Article 19? यही सवाल है. ये तो clear है, you can go to court. But here, can you go to court after emergency? Because it suspends Article 19, it doesn't suspend enforcement, it suspends article itself. So, can you complain of violation of Article 19 after emergency? That is the question. That is the question. So, earlier view was that you cannot go. This is prima facie, looks like suspends Article 19. You cannot go to court because Article 19 is not there. So, मेरा Article 19 गवर्नमेंट ने वायलेट कर दिया, हमें लिबर्टी नहीं दी बोलने की, my freedom of speech and expression was violated during emergency. So, can I go to court after emergency? The answer is no, because Article 19 was not there. This is what is plain and simple view. And this is what most of the people understand. I tell you, this is the irony. But constitution is a specialized subject. एक IAS में बुक आती है लक्ष्मीकांत, उस किताब में भी ये भ्रामक बात लिखी हुई है, गलत लिखा हुआ है. वो कॉन्स्टिट्यूशन के टीचर शायद नहीं है, सॉरी टू से, वो पॉबेट के टीचर है शायद. उनको नहीं पता है कि सुप्रीम कोर्ट ने ये निर्णय दे दिया इस पर. वी कांट बिलीव कि आर्टिकल 19 विल रिमेन Our Article 19 will not be in operation or will not remain in constitution during emergency. We can't believe this. This is unbelievable idea. Article 19 was also there during emergency. Though I could not go to court during emergency because we have given some kind of protection to the government. But after emergency, I will go to the court. So, अब जो view है 358 का, now the view is 358 is very clear. And you can go to court after emergency complaining violation of Article 19. And this was decision in M.M. Pathak versus Union of India. AIR 1978 Supreme Court decision. ये मेरा मत नहीं है, ये सुप्रीम कोर्ट का मत है और बिल्कुल सही मत है. We can't believe कि during emergency Article 19 was not there at all. This is not acceptable. No, 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 no. We can't digest this idea. So if my Article 19 is violated during emergency, after emergency, we will. Can you go to court after emergency complaining violation? Yes. बट अर्लियर व्यू था नो, और बहुत सारी किताबों में अभी भी चल रहा है नो, क्योंकि प्लेन एंड सिंपल तो यही दिख रहा है. बट सुप्रीम कोर्ट ने निर्णय दिया. हमने आपको कहा था कॉन्स्टिट्यूशन में कई प्रकार के अमेंडमेंट. इफ यू रिमेंबर माय लेक्चर ऑन अमेंडमेंट, आई सेड देयर आर मेनी अमेंडमेंट्स व्हिच आर इनफॉर्मल, of which we are not aware if we have not read the constitution in its entirety. The decisions are there. जब मैंने कॉन्स्टिट्यूशनल लॉ का व्याख्यान दिया था, when I explained constitutional, I said bare act of constitution is not only constitution, it is a decision of the courts also. So the decision of court clarifies the point and says that no, Article 19 was in operation even during emergency, though it's a different matter that during emergency you cannot go to the court. But after emergency, you can always go to court and you can always complain of this matter that my fundamental right in Article 19 was violated. So this point I wanted to make clear to you because you are going to be the judges of the country. You should know this. You should not commit the same mistake which is generally committed by other people. Let me tell you further. See, I raised a question. And you can frame many questions. Earlier emergency was in executive's domain because once parliament approves, it goes beyond the control of parliament, and executive will take a call whether to take it back, not to take it back, how many months, how many years. Everything was within the executive. But now after 44th amendment, all the scenario is changed. Executive can take a decision to impose emergency. Now see, I tell you one by one in my own way. See how many checks we have imposed, starting from 352 clause 1. एक तो कह दिया only armed rebellion. See, this is how we have made this provision less monstrous. Not internal disturbance. Internal disturbance was a vague and indefinite term, and this could have been misused by many, so we replaced it by armed rebellion. Second safeguard, we said written advice. Third safeguard, we said advice will be taken by Union Cabinet. Fourth safeguard, approval within 1 month. Earlier time was 2 months. Now it is 1 month. Fifth safeguard, it is now dual majority. Earlier it was simple majority. Earlier it was not clear that for how many years and months it will be. Now it is clear that after 6 months you will have to take again approval of parliament. if Lok Sabha revokes, or you write like this, if Lok Sabha suggests revocation, then it is must for president to revoke. So एग्जीक्यूटिव की अथॉरिटी को हमने काफी कम कर दी. Must for president to revoke. So we imposed many safeguards, many safeguards. ठीक है. So I hope you understand that there are many safeguards have been imposed now, and the executive tyranny which can be there, which could have been there, will no more be there, because Parliament is a sacrosanct institution and it will keep this constitution intact, as Supreme Court does time and again. So Parliament has been made. Now see, Parliament is representative of the will of the nation. So now, earlier it was in the control and command of executive, now it is in the control and command of Parliament. So this is the major change brought by 44th Amendment, and for this Janata government will be remembered forever. It is not the Janata government has done marvelous works and not the other Prime Minister. I am not saying that I am not into any party, but just I am trying to convey the idea that as far as constitutional crisis which was created by the then government of Indira Gandhi has been somehow tackled by 44th Amendment, by this Janata government, where they made various changes here and there, and that is how they want to democratize the constitution, and that is how they wanted to minimize the tyranny, the executive excesses which might have been done even in future. So we took corrective measures for future course of action. So you see the changing pattern of constitution here, that from the executive domain it has come to Parliament's control. From executive excesses to it has come to Parliament's level, and Parliament has been given the role of sentinel on qui vive now. Parliament is expected to behave properly. Parliament is expected to control the executive's excesses and tyranny. And this is what we have done by 44th Amendment. I hope by this lecture you must have understood what is national emergency. I have told you very clearly that national emergency can be imposed time and again. 3 times it has been imposed in our country, 2 times on the ground of external aggression. The first one was Indo-China, the second one was Indo-Pak, and third one was internal disturbance. You know this. First one during Nehruji's regime, the second one during Indira Gandhi regime, and third one also during Indira Gandhi regime. But thereafter there has been no imposition of national emergency so far, and we are in peace, we are in calm. I don't know when this peace and calm will be a distant dream, because China is again and again transgressing into our territory, and we'll have to retaliate and react. Thank you very much. Read this Bear Act carefully. Read all the provisions carefully. Do revise your class notes carefully. Do read your material carefully. Is this clear? Thank you very much. God bless you. If you have any question, do ask me. Thank you very much.